commenting about the merits and demerits of the case. Of course, the same applies to filing copy based on interviews that you conduct sometimes as a journalist with claimants. They may not be defense counsel this time. Of course, claimants are found in commercial matters or civil matters. And the interviews that you sometimes conduct with accused persons. And again, you need to be careful. The media suffered before. The quick one that comes to my mind is a case of a lawyer who sued the National Media Group over a story. It is not even a story, so to speak. It's a picture. Yes, it's a story because it's a picture with a caption. So there's this picture of a woman who is in the company of a lawyer outside the courtroom, in the corridors of the High Court, and the caption says that the lawyer has taken off with the client's money. So where does where does the caption draw its message from? From an interview between the photographer and the lady who was a claimant in a case. And what does it later turn out to be? This lady was not even a client of the lawyer who she was standing out with. But the lawyer, whether it was true or not, but the woman allegedly told the photographer that the lawyer had received money in connection with some commercial matter and had not released this money to the lawyer. Sorry, and had not released the money to the client. So we need to be wary about that. And then, of course, the others are how do you file a copy that is based on proceedings in court but are clearly marked in camera. If a proceeding is marked in camera, even if you had access to it, then be sure that you are there for entertainment, to entertain yourself, or for enriching your understanding of things, but not necessarily for filing copy. Because if they are in-camera proceedings, it means that it's just for the parties and the judicial officers in that court, and they are not for public consumption. Of course, this is also covered in the guide. You will see how do you deal with children's matters, the vulnerable groups, and so on. They may not have been dealt in detail, but we need to be very careful about in-camera proceedings because you risk many things, including, of course, contempt of court. Can you file a copy that is based on briefings by court clerks? Be very cautious. A court clerk has his job, which he does there, and it ends there. His role should be limited to giving you what is in the court record. Please don't ask them, how did it go, what happened, and so on, and then you go and file a story. We have an instance, of course, it's because of the time limitations. I have actual cases where a local newspaper published a story about a forest officer somewhere who had appeared before a court of law and charged with logging from the forest that he was meant to guard. But it later turned out that the forest officer, there was no forest officer who was charged. That particular forest officer was never charged before a court of law. And of course, he successfully sued the media house. And where did the journalist on the ground get the story? He got the story from a court clerk. He was never given access to a charge sheet. He never read the notes of the magistrate. The person never appeared in that court. Can you file a copy after accessing a court file awaiting writing of a ruling? If a matter has been listened to and then it is awaiting ruling, which means that it is under lock and key in a magistrate's office or in a judge's office, the question here is whether you can, if you access the file, you may probably the clerk who is manning the locker is your relative, and they are able to give you the file and you're able to clean through it and write a story. Is that something you can do? and yet you are aware that it is awaiting ruling. You have not been part of the hearing. You may not know what transpired, and so on and so on. I'll give you an answer based on a case again here. Fortunately or unfortunately, I had the opportunity to do the case. In this case, it involved the former President Mwai Kibaki. At the time of doing the case, he was president, but the matter in issue arose when he was campaigning to become president at one point in time. So when he became president, there was an application to remove his name from the civil case that had been filed against them. And of course, using our connections, I was not the only one who filed this. It was covered by other media houses. Two or three of them, I think two of the media houses. Of course, we were given the file by the court clerk. We linked the file and filed a copy. And in the copy we were saying the case is coming for ruling on such and such a date, and this is the application. Of course, the ruling was in my favor. Whether this is a precedent which you can hang on, of course, it needs to be tested once more. But in that case, of course, the High Court ruled in my favor, saying that the story was accurate, and there is no law that prohibits a journalist from accessing a court file unless they have broken into it. But if they legitimately got the court file by asking the clerks to provide it, and they limited their writing to what transpired in court, and the stories presented accurately, indicating when the matter was last in court and the status of the case, then there is no harm in filing such a copy. Can you rely on the prosecution file to file a story? A straight answer from me is no, you can't. Please, if the matter has just been taken to court, a person has been charged, the prosecution have not presented their case, do not look at the prosecution file. Stick to the court file. Two different things. Prosecution file and the court file. So stick to the court file, leave the prosecution file alone. Most of the time, of course, we make this mistake because we say we went in, it was a plea, there is no need for the story. And then, of course, you talk a prosecutor, and then he gives you what is in his file. And then you produce that which has not been presented and tested before a court of law. Can you file copy based on interviewing other journalists on a matter where you were absent when it took place in court? I will be surprised if there are many of you who have not done this before. But if you have, pray to your gods that each time you get this briefing, it had better be accurate. Because if it is not accurate and it culminates in filing of inaccurate copy on cases you did not cover in person, then obviously you are going to be on the receiving end. Always try to report for your media house based on your own experiences in the courtroom. If you missed a matter, you were not in court when it was going on, please ask for the court file, which will be given to you. Look at that court file, make your notes out of the court file, file your story. If you wish to get information from another journalist, and especially a journalist from a competitor, chances are that the journalist may mislead you. But sometimes there may be an innocent mistake, even when the journalist did not intend to mislead you. But of course, it may look innocent, yes, the journalist does not want to mislead you, but nonetheless, the story that you have filed is inaccurate. So you will have to be on the receiving end. Can we editorialize? Can we make commentaries on cases that are pending in court? Of course, the general answer is no. If a matter is live, we have no reason to editorialize, we have no reason to comment. And the commentary here means that we can't get into analyzing the evidence and passing judgment. We can't get into issues of saying so and so has a better case than the other and so on. That is a preserve of the courts. If you want to analyze evidence and make your decision on the evidence, please wait until judgment has been delivered and then analyze that judgment and make your comments on it. And I hope that will be clearly in a section either in a column or in a section that is clear, that is not news, is an editorial, it's a commentary. And very finally, on the booby traps, we need to be very careful to distinguish between criminal and civil cases, because there is a danger if you mistaken a criminal case for a civil case, then or a civil case for a criminal case, then obviously the parties involved will not take it kindly. And I can quickly give an example of one of the court cases that I can lay my hands on, where there was a sexual assault at a sports club, and the assault was basically, whether deliberately or unintentionally, one of the caretakers at the sports club flashed out people who were still in the changing rooms. And one of these people who was a child, then the child came out and was nude. So of course the parents of the child filed a case against this caretaker of the club, which was Parkland Sports Club. Now, this is not a criminal case. This is a matter that just attracts damages. So basically, what happened finally was that the headline was 50,000 fine for sexual assault. Of course, there are many impressions that one creates. The magistrate who was hearing the claim, the civil claim, of course, filed a case against the media house, and of course, the media house was found on their own. And this is merely a question of mixing two cases: a civil case packaged like it was a criminal case, because there was hue and cry everywhere. Sexual assault has certain connotations, and people interpret it differently, and they were saying, this is a joke. How can you just find somebody 50,000 shillings who has sexually assaulted a girl, and so on and so on? But that's not exactly what it was. It was something else. Now, having pointed out the booby traps that we need to be clear about, I want to finally suggest how we can steer clear of those booby traps. And it will not take even 3 minutes in what I'm sharing with you. One, let us try to be accurate as possible. Let us try to be as accurate as humanly possible. And accuracy must be in terms of context, and it must also be in terms of content. This is not about law, this is about journalistic practice. If you look at the Code of Conduct for the Practice of Journalism, if you look at the 25 guiding principles or guiding values, or the values that are contained in it, the first one will be on accuracy. So accuracy saves you a lot of trouble. Get it right in terms of content and in terms of the context. Even if anyone will complain against your report, they will merely be wasting time, because you are able to demonstrate that what you presented was accurate in terms of content, and it was also accurate in terms of context. Number two, for us to steer clear of booby traps, let us understand the breadth and width of qualified privilege as a defense available to us as journalists. And to some degree, let us understand the breadth and the width of fair report privilege. And let us also understand the defense of justification. And lastly, let us try to understand the court structure. Let us try to understand the court language, and let us try to understand the processes of the court. In my view, if we appreciate and observe the three, we will enjoy court reporting. Let us observe accuracy, Let us understand the breadth and validity of the privileges that are available to us, and let us understand the court system, the court processes, the court language. Thank you, and I will now leave it at that and open it up for Q&A.
Nyakundi, for that elaborate presentation and illustrating obviously various issues with practical examples. Very useful, I think, in deepening an understanding of what should be covered and how it should be covered, the issues of accuracy in terms of context, in terms of the arguments that are advanced in court, what journalists should access from the courts and what they shouldn't access. I think those are important. I want to tweak the program a little bit. Given the issues that you've talked about, I think it's maybe important for you to take a few minutes to get your voice back. I suppose maybe talking for 1 hour sometimes is long, but also to bring in another context, which is what really determines the editorial selection of content from the court. And Wangedi has had, I'm sure, many opportunities to select cases, to publish, and I'm sure some stories have died for various reasons, and that would also maybe provide us with knowledge on what determines selection or sometimes deselection of certain content from the courts and obviously elsewhere. But in this case, we are interested in court material and reporting from the courts. Let me invite Wangedi to come in and maybe share his own experiences as a way of enriching these conversations. And I would seek your indulgence, the participants. We don't have much time, but if we can finish this maybe after 1, we intended to finish probably 12:30. But because of the delays, we maybe take a few moments to go through some of these issues that we wanted to cover today. Wangedi, let me invite you to come on, please.
Well, thank you very much, George. Dr. Nyakundi has covered this subject so in such detail that I'm actually wondering what I'm sitting here for. I should have sat with him to compare notes so that we do a joint presentation. He has wandered in the newsroom, wandered in the court corridors, and everywhere else. And thank you very much for that, actually. If anybody in the team feels at the end of the session that they haven't actually picked up some, it will be a very sad day for all of us. Thank you very much. Let me start by saying that just recalling some of the comments that were made during the launch of this guideline for court reporting. And I don't know if it was Churchill or his vice chair who said something like, over the years, the courts have been a very strong source of captivating stories for the media. Catchy headlines, dramatic content and stuff like that. And it's true. I'm making the point from that it makes sense for us to review our understanding of the court system, of the way courts are reported, and increasing our knowledge of that skill itself, which again validates this forum. But when we look again at what we have now in our media in terms of court reporting, you begin to wonder what has happened to all that reporting. It's like the shine has gone off court reporting. There is very little coverage of the courts. I looked at 5 editions of The Nation and The Standard over the last 5 days or so, and I was hard pressed. I had difficulties actually identifying court stories in those papers. And yet there was a time when if you opened a copy of the Nation on any day of the Standard, you'd find a page dedicated to court stories. The branding would be something like court roundup or something like that. The stories about crime, about sex, about robberies, and all that. Today there is very little. So you wonder what has happened. Is it that the quality of reporting has been so bad that editors are not creative? We didn't get it from those of us who are to move your mics. So I thought I should mention that because it seems to be making a very strong point about where our court reporting is headed to. Now to the newsroom, what are our editorial considerations or expectations when reporters go out? Well, first of all, what the editor wants is a good story. He trusts that the reporter who goes out to get to the coast to bring a story will put out his best foot and give him a solid story that is well rounded up in all the elements, containing all the elements that Nyakundi has spoken about. That he shows a good grasp of the knowledge of knowledge in terms of what he's writing about, and that he has written the story within the deadline, and it has as few mistakes as possible. It's as accurate as it can be, and it also covers a matter. It's also about a matter that is of great public interest. Stories are killed for two reasons. One, they are written in a very pedestrian way. They are inaccurate, or they are filed out of time. And by the time you pick it up again the following day, somebody else has already published it, and therefore they have no time to waste on it. But the most important thing is the way the story is written, how the arguments are weighed through, and the interest, the topicality of the subject matter itself. The other thing that they look at is all the bobby traps that Nyakundi has spoken about, because the last thing the editor wants is to find himself being exposed by a reporter who has little understanding of the issues Nyakundi has spoken about, and therefore by publishing a story he is inviting obvious litigation. And we make mistakes even as editors. I've made a few mistakes myself, and I'll show you, and I'll be showing you an example, one example or two in terms of mistakes I've made. And it took me a long time. It took me a long time to get my newsroom to understand these bobby traps. I would issue memo after memo trying to draw their attention to the dangers of basing a story on affidavits, but it was the realization didn't dawn on them until I shared with them the amount of damages that we were paying the people that were offended by the stories that we were writing based on affidavits. So that's one. In fact, let me just show you this, an example of what Nyakundi referred to in the story of the lawyer and the woman that we claimed in the caption was a client, and yet there was no lawyer-client relationship. Somebody will have to help me here to share the screen. George.
Yes, where is the content?
George?
Yes, I'm here.
George is there.
No, I'm here. Can you hear me?
Well, I can hear you. I want to share something here.
On your at the top of your the browser on the platform, you can see a sign of a to-do.
Yes.
Click on that.
It says start sharing screen.
Yes.
But nothing is showing up.
Nothing is coming up.
No.
All right.
Oh, sorry. Wait a minute. 1 second, guys, 1 second. It's not happening. It is not happening.
Is it not? Able to see. I think something happened to it. Because even when I click on it,
Anyway, let me see whether I can talk. I have the copy on my screen. Let me see whether I can pick out the issue that I wanted to talk about.
okay.
So this was a case involving. The headline is something like what? Let me see. Republic of Kenya in High Court at Nairobi. JP Mashira, that's the advocate, as the plaintiff, versus Wangari Mwangi and the Nation newspapers. Mashira, the lawyer, sued the Nation for defamation for a story that we had published, which claimed that he had evicted a couple from their current house and had demolished or was in the process of demolishing the house. There was a transaction between them anyway. That was not in dispute. The man of the house apparently wanted to sell the house to Mashira, and Mashira paid the deposit, but the deal fell through. Then the wife comes in later and claims that she was not party to the discussion, and that in fact her husband was mentally unstable and was at Mathare Hospital, and therefore Mashira, by insinuation, was taking advantage of a sick mind. So to cut a long story short, we went to court and pleaded justification, truth and all that, all the things that Jakundi has spoken about, absolute privilege and all that. Believing all the time what our reporter told us, that he based his story on the actual proceedings of the court. He listened to everything, he saw everything, he didn't interview anybody, and he produced his notes to confirm that he had actually based his stories on his story. There were 3 stories, or the stories on the proceedings of the court. What the judge actually found out was that while some of that may have been true, a lot of that text was derived from an affidavit that the wife of this man who was selling the house to the lawyer had shared with the reporter. But the reporter did not share that knowledge or that fact with the editor. So we went to court and argued back and forth, believing that we are on the right footing. And this is what the judge said. Let me just pull out 1 or 2 statements. 60, 58. It's a very long judgment. This is one of the comments that the judge made. I am fortified in my conclusions on the issue of privilege by the legal authorities that seem to suggest that until documents are formally put on the floor or raised in open court or become the subject of the attention of the judge, they would generally not be amenable to publication in a newspaper. As such, they would not be entitled to privilege. So we lost at least on that score, that one on that score. Then the second thing he said was this. As earlier pointed out, this amounted to mining information from documents that had not been brought up on, and then he quotes the data, according to the proceedings, and are therefore not privileged. The question is, why did the defendant reporter lay out this information in his story, which the parties had not referred to in the application for agency? And then he goes on to dispute, to just kill arguments. And then he goes on to say, I'll skip a little. In this regard, The bold title to the newspaper report, referring to the headline, "Lawyer flattens his client's house," read in the context of the whole report, was therefore suggestive of the fact that the plaintiff had admitted to unfairly demolishing the client's house, which he hadn't anyway. And then he goes on to say the statement that the lawyer was currently the husband of this lady was currently admitted at Mathari Hospital is also inaccurate as it was not reflected in the proceedings. So here you have a judge. He's looking at the recorded proceedings of the court on the 3 days or 4 days that the hearing took place, and we cannot use proceedings, the recorded proceedings, with the reports that the newspaper published. And he goes on to talk about, how some of those reports were based on false information, inaccurate, bias, and so on. And then at the end of it, the good judge decided he got on the report and he slapped up with the damages of 5 million shillings. And that was in the first case. The other case involved me. If you recall the drama that the country went through after the disappearance and subsequent discovery of the mutilated body of the then Minister for Foreign Affairs and International Cooperation, Dr. Robert Ouko, and the subsequent setting up of a commission of inquiry just to try and get to the bottom of that whole tragedy. Anyway, his brother, who passed on the other day, had been a senior government administrator, serving up to the level, I think, of DC, decides to generate an affidavit where he accuses all sorts of people of all sorts of conspiracies and putting the blame for the tragedy that befell his brother at the doorstep of these people. And one of them was one of these prominent lawyers in town. So foolishly, I'm looking at this thing and I'm saying this is a matter of great public interest. So I published that affidavit. The next thing I knew was I was getting summons from Kisumu, where the Commission of Inquiry was sitting, to go and explain myself. Again, foolishly, I went and tried to argue that, an affidavit is a court document. It was tendered in court, and blah, blah, blah. Of course, they wouldn't hear any of it. I was asked to to apologize. First of all, the nation was kicked out of the Commission of Inquiry for that. And then the second thing is I was asked to to publish an apology in the newspaper before they could consider our request to be readmitted to the hearing of the Commission of Inquiry. So again, foolishly, I pen an apology with the advice of a lawyer and I put it on page 2. And then I go back to court, to the Commission of Inquiry. They wouldn't even entertain me. I stood at the door and I was told that's not what we expected. The apology should have been published in a prominent place, almost equivalent to the prominence that the offending article was published. So I did another one and put it on page 1, but we didn't get readmitted immediately. We were kicked. I think we stayed out for quite a while. So, Nyakundi, you are right. Everything that reporters that we send to court do, they must realize must happen inside the courtrooms, not outside. Whether you are friends with a lawyer or the court clerk or witnesses or whatever, what you take back to your newsroom is the evidence of what you have witnessed in the courtroom, whether it's the drama that Nyakundi was talking about earlier, or the arguments back and forth between the court officers and everybody else. That's where it starts and where it stops. The other thing that we expect from our reporters is a measure of integrity and honesty. Nyakundi mentioned the issue of where you are unable to attend court for one reason or another, and it's an important story that the editor expects you to bring back, what do? I handled one case like that during my time of a reporter who was sent to court, but he missed the hearing because he was stuck somewhere. Cleverly, he thought he talked on the side, he spoke to either a lawyer or a reporters, some buddies of his, and filed a report that was it turned out it was the complete opposite of what had gone on in court that day. We had no choice but to let him go so he could do his misadventure somewhere else. The other thing that we expect from reporters is, again going back to integrity, is we've heard of this concept of court cartels, where reporters gang up together and decide which court to cover or which case to cover and which one to ignore. And this is usually done for a consideration of, I don't know what kind of money they are paid or who pays them. But what every editor will tell you is that sometimes they find themselves at the mercy of court cartels or court cartels that involve reporters, court reporters, particularly senior court reporters, court clerks, and some lawyers. And that really damages the reporting of reporting from the courts. What was the other matter? So I've spoken about, good story writing skills. And when you talk about good writing skills, you are trying to look for angles that not sensationalize the matter that you listen to or witnessed, but to give it a kick that will gel with the reading public the moment your paper hits the newsstands. And there's an example here I wanted to share with you. I'll just read, since I'm not able to project it on the screen, I'll just read. This is how the intro is written. A cowardly assassin killed an innocent mother of 9 and her nephew in a botched revenge hit after rivals shared a trophy image of the attack on him via Snapchat, a court had. Then we have the name of the attacker, Obino Ezra. I've changed the names here. Obino Ezra, 28, allegedly crept into a family home and shot a 1-year-old student burial in the back of his head while he slept in bed as part of a vendetta of violence. He then blasted the victim's aunt, the name is given, in the chest when she came out of her bedroom dressed only in her underwear in the other hours. You notice what is happening here. We are not told the difference between the way these stories start and the way we normally see stories in our papers is we go straight into the accusation or the charge. A man was charged yesterday with blah blah blah, but here we are starting with the drama. We are starting with a hook that draws you into the story, and you can see the skillful way the reporters have handled the matter. So all the way down, you don't come to the charges until much later. And then the other thing you notice is nowhere in the story is the judge's name mentioned or the jurors' names. It's all the drama of what of the events of the day without bothering. And the reason that the judge's name, for instance, is not mentioned is that he hasn't made any comment. He's just sitting there listening. While in our case, we would start by saying the chief magistrate so and so yesterday had ABCD. And that brings me to another point. When we are looking at what our reporters have brought back into the newsroom, we're also trying to see the extent of which that story reflects the understanding of the internal editorial policy. And the nation's policy, for instance, can be very brutal in terms of the things that it requires reporters to do. So, for instance, it will tell reporters, let me see if I can pull out this, that not every detail in a court story is important. For instance, wait a minute. If you are covering, for instance, a theft, a story involving vehicle thefts, for instance, journalists are advised not to bother with the details of the car registration numbers or whatever. And if it's the magistrate court, unless the judge or the magistrate makes an important point that takes the case forward, there is no reason to bore your readers with the names of these magistrates or the judges. Then there is the question of the protection of children. Again, it's very clear in terms of what it requires. Reporters covering cases involve children, what they should do. So there is that. And then, of course, there is the what to do when you are covering a case involving victims of sexual offenses. And I think that we touched on this. And then finally, there is one on innocent relatives. Very often you see somebody hauled to court on a charge of theft or corruption. And the first thing you see is a reporter attempting to bring in the poor guy's prominent relatives as though they are part of the equation. Well, sometimes it can be justified, but in most cases, you're just exposing innocent relatives and friends to a matter that they have no control over. Let me see whether there was something else. Something else, yeah. Language. How well do you understand, like Nyakundi was saying, how well do you understand the language that defines court reporting? Let me see whether this case is the one I'm looking at. There's a story that was published, I think, yesterday or the day before, and the headlines read something like this: activist to face kidnap charges. And the intro says, that's the headline, the intro says, COVID millionaires whistleblower Godwin Otieno Wagutu and 2 other men will be arraigned for abduction this morning. Not for alleged abduction, but for abduction. That immediately suggests that these guys are already guilty of what they are accused of. The headline itself is as accurate as it can be: activists to face kidnap charges. But the intro seems to suggest that he actually was involved in a kidnapping matter. Then the last one is, let me see. Sorry, I can't find the other one. Sorry. So, bottom line for the newsroom is the extent to which your story satisfies the editor that you are actually in that courtroom and you have reproduced the proceedings in an as accurate, comprehensive a manner as you possibly can. Then you leave the rest of it to the editor. And there are 2 forms of reporting that we used to look at ourselves or continue to look at. One is what we generally do, which is indirect reporting. This and this happened. And the other one is a literal transcription of the proceeding itself. And that is determined most times by the case itself, the public interest in the case, the extent of the public interest in the case. And I can give 2 examples. One of the Oko Commission of Inquiry, and one was the SM Otieno Barrio saga. And the intention here was to try and bring the ordinary reader through our reporting into the court. The reader out there has no time to go to court, but we wanted to give him a sense of being present in court. Hence the reason for us to reproduce as much of that reporting in verbatim as possible, and did wonders in terms of the interest is created. I think that's all. Back to you, George. George?
Thanks very much, Wangedi. I was trying to turn on my video and everything else.
George?
Yes, I'm here Wangedi. Can you hear me? Wangedi?
Hey, Nyakundi. You are muted.
Nyakundi, turn on your video. Your audio, rather, your mic. And Jeru, did you mute everyone?
I mute everyone.
George?
Yes, I can hear you, Wangedi. Can everybody hear me?
Yes.
I'm done. Sorry, let me just make one more point. One more, just that.
Proceed, Wangedi.
Yeah, the manual talks about sources and tries to give reporters tips around the purpose. And I was wondering, and this is something we can discuss in Nyakundi, I was wondering how much room there is for reporters to rely on sources for their court reportings. Forget about affidavits. In general stories, we rely a lot on sources, anonymous sources and the like. And sometimes you get yourself into a lot of trouble because of that. But in court cases, I see very little room for use of sources. But we can discuss that. Okay, Joe.
For that presentation, I'm sure participants appreciated that experience from an editor's perspective. I think that is critical because sometimes they don't understand why stories die or why stories are problematic. And, as editors, you probably asked several times why, stories have died. And I remember working in the newsroom, maybe you've been in court the whole day, and the next day you're expecting maybe a big headline. And, you turn up, you probably as a young reporter, go to the newsstands maybe at midnight because you want to catch the paper. Those days, the paper used to come out at midnight, and you find that your story has not been published. And you wonder why, the editors decided to kill your story. So those examples, I think, are important in illustrating the challenges sometimes that exist between the reporters, court reporters, and the editors. You've talked about the integrity of, the reporters themselves, but also the media houses and the challenges that sometimes obtain the tensions that exist between not only the courts, but also between the journalist and the editor. So there's a lot to discuss, there's a lot to comment on, and maybe I invite participants to ask any questions. Wangedi has taken leave to ask the first question, perhaps, on whether you can rely on sources or anonymous sources when reporting from the court. So Nyakundi may want to address that. But let me ask maybe participants to ask other questions before Nyakundi can respond. You can also ask Wangedi any questions that you may have. All right, the floor is open. Anybody wants to go first? But before we proceed, let me ask whether colleagues are willing to take maybe another 30 minutes because we were supposed to stop at 12:30. Now it's 1 o'clock. Whether we can have another 30 minutes of discussion before we close this session. Is that okay? Okay, I suppose that is okay because nobody has raised any objection. So yes, let's have 30 minutes. And before maybe we ask the first question, there is a form that has been pasted on the chat. Please take a few moments to fill that as a way of capturing who was in this session, but for other purposes as well that Abraham may explain later. All right, the floor is open then. And you can just unmute yourself and ask any questions. Jeru might help to unmute you if you have challenges. But you can also post any questions that you have on the chat, and I'll ask it on your behalf. So anybody wants to have the first go? All right. I think as participants think, I thought they've had an opportunity to think about any issues that they may want to raise. Nyakundi, you may want to maybe respond to Angedi's question.
Thank you, Prof. What I would say, if I understood Angedi's question, what I would like to say is that sourcing or cultivation of sources is just the same everywhere, including the courtrooms or the judiciary. So if you have sources within the judiciary, the best they can do in that case is to tip you to where you will get a story. For instance, if you have cultivated a good relationship with judges, if a judge is about to deliver a ruling which in his view he thinks is unprecedented or something that will interest the larger public, this judge may send you a text, or you have this executive officer or this clerk, and they are basically tipping you to getting the story. It won't be in the sense that they will be the one originating.